Hello, everyone, and welcome to Mountain States So When They Were Asked, a monthly webinar series from Mountain States Legal Foundation, where our expert attorneys answer your questions, help you understand the Constitution, the law, and the principles of liberty. My name is Stanton Skurjanik. I'm the communications manager here, and I will be your host. Before we begin, I want to tell everyone who we are as Mountain States Legal Foundation. MSLF is a nonprofit public interest law firm dedicated to restoring those rights found in the Constitution at zero legal cost to our clients. We are focused on protecting property rights, economic liberty, the right to keep and bear arms, free speech and association, which we're going to be talking about a lot today, and equality under the law. We do so from our headquarters in beautiful Colorado. We litigate crucial cases across the whole country, though. We are a national law firm, and we are focused on those cases, especially that are going to make a difference in this country. Today, I am joined by Mountain States Legal Foundation's very own General Counsel Will Trackman and our senior attorney, Jim Kerwin. Hello, gentlemen. How are you today?
Hi, Stan. Good to be here. I'll just put in a general plug for sunscreen while we're here. I had a little bit of a thing yesterday. I'm all good to go. You should see the other general counsel. But if this is distracting, that's why. I'm all fine. Thank you for everyone's concern, though.
How was your Thanksgiving? That was just last week. Plenty of turkey, I hope, and the finest of mashed potatoes.
Yes, I'm still need to work it off a little bit.
Right,
I had a terrific time. I hope you did too.
You know, I like to pretend that I earn my Thanksgiving dinner, and well, I guess it's like 2 dinners by how much you eat, but you know, you just don't think about that at the holidays. You wait. That's what January's for. That's what January's for. All right, so for our viewers here online, many of you are returning viewers, so welcome back. For you new ones, we usually have some sort of question and answer session about the 30-minute mark or so. There is a Q&A button here on Zoom if you're joining us there. If you are on Facebook Live, I'm monitoring the comments over here, so you can ask your questions as well. So feel free to ask those questions. We may not get to everyone's questions, but we appreciate you asking them nevertheless. So let's dive in. So a neighbor asked, what speech is protected? How is Mountain States defending free speech in our great country? And what cases have we taken up to ensure that Americans can be free in their thoughts and their words? And Jim, you're our main guy on free speech, so I'm going to take this first to you. And I'll ask what I suppose is the most obvious question. Isn't all speech protected? Like, can't I say whatever I want, whenever I want in a free country?
Well, thank you for that question. It does seem like a sort of obvious question. If it were that easy, there wouldn't be much work for the lawyers. The short answer to that question is no. While free speech protections are very broad in America, they're not unlimited. Sort of the most obvious example might be that there are certain crimes that you commit through speech. So there's the crime of fraud, where you convince somebody that there's something of value, essentially with the intention of swindling them out of money. That's done entirely through speaking. So is perjury. Those are sort of obvious examples. And there's a few other very limited categories of speech that historically are not protected under the Constitution. Inciting a crowd to engage in a riot would be an example. Threats, defamation, ruining somebody's character through lies, that sort of thing. But these are pretty narrow categories. There's also special rules for certain kinds of speakers in certain situations. One good example of this, which I think we'll spend some time talking about in this webinar, has to do with students in K through 12 education. Okay. Schools do have a little bit more free hand than other government actors in regulating the speech of students, where if an adult said the same thing a student said in a K through 12 school, sometimes the adult would have a First Amendment right to say it, but the student may or may not, depending on the circumstances.
Right.
So that's the short answer to. I'm sorry.
He can't just blurt out something whenever he wants. There's got to be some level of discipline in a classroom setting.
That's right. There's a balance between the rights of students to speak freely, which they do have, but the needs of the school, because it has such an important role in society of educating students. So, for example, if a teacher has a quiz and the students are required to answer verbally. I mean, that is a limitation on the students' free speech rights or their, on their speech.
I
If
am
you get an F
compelling you to
because you,
answer my question in class, right? That kind of thing. Like that's now I know, we usually say compelled is very bad, but I want you to answer my question, little Johnny. That's a very important distinction there. Okay, that makes sense. I mean, I think a lot of Americans usually, they hear this phrase, you can't yell fire in a crowded theater. Does that have any merit here? Like what's that principle behind?
that's an older Supreme Court standard, but it's wrapped up in one of the exceptions that I mentioned about speech that's intended to and likely to cause imminent lawless action, that sort of thing. But yes, there are certain emergency situations, again, where technically all that the person is doing is speaking, but it's going to cause some terrible social harm or perhaps death, or a stampede at a movie house, something like that. Those kinds of cases are cases where the First Amendment would not say you have a right to do that, even though it's speaking. But again, those exceptions are very limited. And at Mountain States, unfortunately, the trend these days is for government actors to try to expand those exceptions to free speech more and more and regulate more and more speech. And we're trying to keep those exceptions as narrow as possible.
Yeah, absolutely. Absolutely. I feel like there's a lot more layered in there. I know there's a whole free speech thing with national security thing. Like I don't even want to touch that because that's such a complicated thing. So I guess, and that's a good question, right? There is so much to free speech and free association. And Will, you're a general counsel, so you are a big part in developing our legal strategy to take the Constitution on the offense. So with all of the options that we have in defending free speech and the opportunities that exist for that, what has Mountain States done in the past to take this fight? What has been our approach to defending free speech?
It's a great question. So Jim's going to talk in a second about some of the cases where we're involved in direct representation of clients alleging First Amendment violations. In the past, in other cases, we've gotten involved in cases as a friend of the court or as someone who files an amicus brief. So even though the court has other pleadings in front of it, we go ahead and file a brief and seek to have our voice heard in the case. And we have been going to where the fights are in those situations. So the Supreme Court last year decided a very prominent case called 303 Creative, involving the question of whether a website designer had the right to refuse to serve a same-sex couple that was asking for her creative services to design a wedding website on their behalf. And the Supreme Court ruled in a 6-3 decision, echoing some of the arguments that we made in our brief, that the website designer did have a right not to be compelled to speak as part of her services on the website. So that was an important victory for the First Amendment for free speech. We're going to be involved in a similar case just in the next couple of weeks. You've probably heard of the Masterpiece Cake Shop Bakery a few times by now. There's yet another incident. I feel like this must be the only baker in the entire state of Colorado, Jack Phillips. Yeah. So on the day that he won the last case, a transgender identified customer called and asked for a pink and blue cake to celebrate the transgender transition party that the person was going to throw. And once Jack found out that it was for the party, he said, I'm just going to decline service. And of course, that was met with an immediate lawsuit. And that case will be before the Colorado Supreme Court just in the next few months. So the briefing is due right before Christmas. And so Jim and I will be working hard on getting that filed.
You're going to earn that Christmas dinner now, too. So I know that Masterpiece, that Jack at Masterpiece, that a lot of that is wrapped up in some, in religious convictions. Do we take a play in the religious dimension of the First Amendment, or are we focused on free speech only?
We get this question a lot because we say we're First Amendment lawyers, and so the First Amendment has a lot of components to it. It's not just speech and association and petitioning and assembly. It's also the right to the free exercise of religion. And of course, there's the Establishment Clause. that prohibits the establishment of an official state religion. We don't take cases generally in the religion area directly. However, there are lots of cases where the speaker happens to be religious. So Jack Phillips is declining to speak a message that is contrary to his faith. But in a lot of the cases where we file these briefs, we say, look, it really doesn't matter whether the person happens to be religious or not. If you had an atheist baker or a Jewish baker or any baker who had any conviction, and they said, look, I don't want to use my creative services on behalf of a message that I disagree with, we would want to be involved in that case. So sometimes when the party is pressing specific arguments about religious freedom or free exercise, we're there to say, well, actually, there's a whole other reason why you ought to rule in favor of this person that would be a broader, more robust way of interpreting the Constitution.
All right, so I can see that. Then that's where an amicus brief, a friend of the court brief, is going to be really important in making sure that, it is good that they're fighting for their religious freedom rights, but it is equally important to say, independent of that, it's still speech that should be protected on its own. So
exactly,
that's really important. So I guess with that in mind, that that we're all over the country, that we're going to where the fight is. What are we doing right now? What are some of the big cases that we've got going on that y'all are busy lawyers? What's keeping you busy?
I'm just going to mention one case, then I'm going to turn it over to Jim to talk about our Gadsden flag case. We are in a pending case in the 8th Circuit Court of Appeals, which is Missouri, where teachers were compelled to say that they agree with certain diversity, equity, and inclusion training. And the teachers sued, saying we shouldn't have to express agreement with this training, which talks about white oppression and white fragility. And so the court there is deciding whether to reverse the lower court's decision that they didn't have an injury, that there was nothing wrong with being forced to express agreement with those points. And we're really hoping that that case gets flipped, because it's an important principle to make sure that even teachers, even in the school setting, aren't compelled to voice agreement with these offensive principles. So let me turn it over to Jim.
Now, that could have far-reaching impact. That's really important. Yeah, Jim, what do you got going on? I know we all love this Gadsden flag case, so let's hear what do you got?
Sure. So we have a lot of stuff going on. I did want to just talk about a couple of different contexts that we have cases in, and they kind of overlap. One is in the schools context, which is where the Gadsden flag case comes up. And there's also public employment, as Will just mentioned. The case of the 8th Circuit involves kind of both. It involves teachers who also happen to be public employees, and there's different issues in both of these kinds of cases. So just focus on schools for a minute, because that is a very exciting case that we have brought on behalf of a 12-year-old student in a public charter school in Colorado Springs, Colorado, which made a big splash on the internet a few months ago when school officials were caught on video telling him that he had to remove a patch that was on his backpack that had an image of the Gadsden flag, which is the "Don't Tread on Me" flag from the American Revolutionary War period. And the reasoning given by the school officials was that the flag was rooted in racism and things like that. Yeah. So that this young man is really impressive. We're championing his cause in the courts. He has every right under the First Amendment to wear that patch. It should almost go without saying, and it should have been something that the school officials knew. But unfortunately, we think that the reason why this kind of real abuse by the school happened, it's part of a bigger trend. There are two trends that we're really concerned about in public schools in particular that touch on free speech issues. The first is that there are many very controversial and radical views being preached by educators and administrators as if they're undeniable fact. So this is a trend that's going on all over the country. So that this is just an example of that. The idea that the Gadsden flag, which is, to most people, I think, representative of resistance against the oppression of England, 200 years ago, is somehow now a symbol of white supremacy and things like that. People are entitled to their points of view, but these points of view are being taught to students as if there's no alternative point of view.
Yeah, it's that disturbing trend of the ideological politicization of official curriculum, which is really kind of disturbing. But Jaden had a different message.
Yeah, so that's a big problem in and of itself. But even bigger is and much more germane to the First Amendment is that hand in hand with pushing these points of view, there's a strong push to squelching any dissent, right? To anybody that has a different point of view, that's not going to be allowed to be part of the discourse in schools. And Jaden is a person who has a different point of view. He thinks the Gadsden flag represents, a general message of a right to resist government overreach. It has historical significance for him, as it should. He has other messages that he likes to display on his backpack as well. He's a supporter of Second Amendment freedoms.
He's an outspoken kid. He knows exactly what he believes.
Yeah, and it's ironic that of all the things that they're trying to force him not to say, it's the patch about resisting government oppression. So they're like, oh, don't wear a patch that would object to the very thing we're asking or demanding that you do.
Yeah.
So we feel very strongly about this case. It is currently in litigation in federal court. It's moving forward, and Jaden's rights, we believe, will be vindicated by the court. Another area, just to touch on briefly, to move on to another one of our big cases that we're currently spending time on, has to do with public employment again. And just to put that in a little bit of context, when somebody goes to work for the government, they don't give up their right to speak. Now, government officials, this is especially important, not only for the person who's speaking, because they have every right to do it, and the First Amendment is there to protect them, but for everybody else. We live in a democracy, and sometimes what a government employee is going to be talking about is things that are going on behind the scenes, right? They blow the whistle, or they let the public know that the public employer might be doing something that the employer would rather keep a little bit hush hush, right?
Right.
Especially if the employer is doing things that aren't popular, or that are, another way of thinking about that is thwarting the will of the public in a democracy.
Yeah.
So we are about to launch a case of an employee of a government agency in the state of Oregon, where the employer has been engaging in some practices that are likely illegal around race-based employment practices, for preferring certain groups of people based on the color of their skin for promotions and hiring and things like that. And our employee, against a lot of social pressure, was brave enough to speak up and say, I don't think this is right, and I think that this may be illegal. And instead of listening to that, the government retaliated against her, demoted her, defamed her, reduced her pay, that sort of thing. So we're about to bring that case in federal court in the near future.
That's going to be real exciting. I can't wait to share the details. That's one of the things I love about my job. You guys get to have the fun of being in the core. I get to tell the story, which is just great. So I can't wait to tell that story. I can't wait for our viewers to listen in. Jim, there was something about, I don't know if this is for every case. I think it's about Jaden's case. If I remember right, the school justified its censuring of Jaden because it could disrupt the classroom environment, which is generally how schools are able to maintain discipline, but also shut down dissent. What's this? I've heard it before, and I know we've talked about it in the past, but help me understand a little bit more clearly. What is the heckler's veto, and does it have any validity here?
So the heckler's veto would be a circumstance where, I'm sorry, let me back up just for half a second. There is a rule in the context of K through 12 schools that says that a school may limit a student's speech if the speech will cause substantial disruption to the school day. So, for example, if Jaden, instead of just wearing a "Don't Tread on Me" patch on his backpack, decided that he would start a march up and down the hallways, get other kids to join him, come out of class, come here, let's chant slogans, that sort of thing. Obviously, other students at the school are going to have a difficult time learning their math lessons that day.
Right.
So that's a substantial disruption to the school day that would, depending on the facts, possibly legitimate the school in preventing the student from speaking under those circumstances.
Okay.
Heckler's veto is sort of an aspect of this. There's sometimes what'll happen is somebody will speak in a way that's not disruptive, but other people will hear that speech and react in a very bad way. And that the reaction causes a disruption. And the government says, well, then you shouldn't be talking in the first place because look, it's caused this reaction. That's the doctrine of the heckler's veto. We do have a matter that we're working on right now that more directly implicates that. We've been working with a student group at the University of Utah, a group of students called Young Americans for Freedom, which has they're conservative and libertarian, and they, like many other student groups, have sought to hold on-campus educational events. And so, for example, they held an event where they showed a film on the issue of transgenderism a few weeks ago. And they didn't do anything disruptive, but there was an organized group of counter-protesters who came in and shouted down the event that was happening on campus. They came in and flooded the room.
Yeah.
Yes. And so that's and so where does the government come involved here? Because this is one student group talking, another group of students trying to shut them up, right?
Yeah.
The government gets involved because this is the university, it's a public university, and they owe a responsibility to prevent the hecklers from exercising a veto over this Young Americans for Freedom's speech. That's how that sort of event comes up.
Right.
So we get into this and
rights.
Exactly.
Yeah, you can imagine how terrible the incentives would be if left-wing opponents of conservative speech knew that they could always win and prevent that speech from happening by creating a ruckus. Then you'd actually incentivize the disruptive behavior, and that certainly can't be what we want.
Right. No, that makes sense.
And we've seen a lot of these examples that, there are federal judges being shouted down in law schools. There are, speakers who are have to lock themselves in rooms to protect themselves from a riotous crowd of counter-protesters, et cetera. In this particular case, when we heard about what had happened to the Young Americans for Freedom, we wrote to the university administration and we, reminded them that they have responsibilities to protect the free speech rights of in this case, the conservative students. So it doesn't matter, any set of students.
Yeah.
To enforce the rules which don't allow other students can express their views too, but they can't do it in a way that amounts to a heckler's veto. That is, they can't do it in a way that shuts people up by shouting them down and shutting down their events.
We were polite in the letter, but we were also very firm. And we noted that there is case law stating that individual university administrators can be personally liable for damages if they violate clearly established law under the First Amendment. So I think we succeeded in getting their attention with that letter, because the general counsel of the university promptly reached out to us and articulated her willingness to work with us in terms of protecting YAF's future events.
I guess personal responsibility does work some from time to time, right?
That's right.
So politely but firmly,
yes,
we're tackling the heckler's veto in cases where it applies. Politely but firmly. What a very lawyerly thing to say. We're gonna get to some questions and answers here. I have a question myself. We at Mount Sage, we one of the things that we go after a lot is this idea of compelled speech. I've heard a lot about it. We've done a few cases about it. Help me understand, what is it about the Constitution, and I guess specifically the First Amendment, that ensures that the government can't tell me what to say? It obviously can't tell me, it obviously can't stop me from speaking, but no, can it tell me what to say at certain points? How does compelled speech work?
Well, Jim outlined a couple of buckets of categories where speech is unprotected. So whether it's obscenity or fighting words or imminent danger, those are reasons why the government can prevent you from speaking. But it's another thing entirely to say that there are some places where the government can compel you to say certain words or send certain messages. There are, of course, always going to be examples of this. Jim brought up the idea that teachers can be compelled to teach in schools, and we've all seen nutrition labels on products that we buy at the grocery store. But when you're compelling an individual who's just doing their day-to-day job, it's another matter entirely. So Jack Phillips, 303 Creative, those are compelled speech cases. And there's a famous case from the 1940s where government said kids have to say the Pledge of Allegiance in schools. And as part of the wartime effort, obviously we were involved in a very important battle against the Nazis and the Japanese in World War II. And so the school said, we want to say the Pledge of Allegiance every morning. And in the Supreme Court case, striking that requirement down, the court said no official, high or petty, can decide what will be orthodox in our politics. And so the students who didn't want to say the Pledge of Allegiance were entitled not to do that. The students who wanted to say the Pledge of Allegiance still could, and the school could still have that part of the day, but they couldn't force anyone to articulate the words of the Pledge of Allegiance. And that case is often the building block for many of the cases in our modern day.
We all like the Pledge of Allegiance, and yet you can't force someone to say it. And that doesn't just go for, I guess, small things like the pledge. It goes for even big things too. Like Jack at Masterpiece with his case. Okay. There's a question here. They didn't give their name. But this is actually one of the better questions we've gotten. Hi, I'm not really conservative libertarian like you guys, but I follow you a little bit because you're protecting basic rights. I want to know, how is Mountain States acting for people who are censored by social media? I don't know if they're referring to any one platform or not, but like, how does, and because that's a good question, right? Social media companies are private. Is that, how do we deal with that question?
Yeah, that's a fascinating question, and I think you've put your finger on why it's a complicated one. So I think what the person is probably referring to, there's been news about social media companies labeling certain points of view as disinformation, for example, when people questioned the mandate to wear a mask during COVID or get a vaccination, or had different kinds of questions along those lines. Some social media companies would have their computer algorithms take those posts down or reduce their reach or something like that.
Right.
And there has been, much more to the point of the First Amendment, a lot of information coming out recently that these were not just the social media companies deciding that they would just limit certain kinds of messages on their platforms, but in fact, government actors were working behind the scenes with the social media companies, and in some cases, kind of threatening them to take down specific posts. So, and this highlights the issue here. The First Amendment, like almost all other constitutional guarantees, works directly only against the government. So yeah, it's your First Amendment rights are only that you cannot have your freedom of speech abridged by government actors, not by private actors. So generally speaking, because their social media companies are owned by private companies, it would seem that there isn't a First Amendment issue here.
Right.
But there's an important
Facebook or Twitter of their own initiative had moderators going through and taking down posts that they didn't want to be associated with. That's it may not be fine in the social context, but legally that is permissible. But you're talking about something different. It's not just their own initiative.
Yeah, that's right. I mean, to give an example, not in the First Amendment context, that makes this pretty clear. If a law enforcement officer knew that they didn't have probable cause to search somebody, and so they knew that they would be prevented by the Fourth Amendment from doing that search, they can't then go find a private party and say, go search that guy or else you're going to go to jail, and then claim later that there was no government action and the Fourth Amendment just didn't apply. So that's, in a very simplified way, what appears to have happened with some of these social media companies. There was an important case, I can't remember which circuit it was in at the moment, where there was a judge who issued an injunction based on some information that came out in discovery in a lawsuit by the state of Missouri, and also a lot of individuals, including some very prominent physicians, whose posts on social media companies have been taken down under these misinformation policies. That when they dug into it, they found out that in fact there were officials in the Biden administration, including in various agencies, which I believe included the FBI, definitely included some, individuals at the White House who had reached out to the social media companies specifically to say, we are very concerned about this particular post. And in some cases, had sort of veiled threats against the social media companies that they better take down these posts if they want to stay in the good graces of government.
They
Under
know
those
they
circumstances,
can't censor it directly because they're the government, so they're applying pressure, saying if you don't play ball here with us, then we're going to make life real hard for you. We're going to send regulators. We're going to do blah blah blah. Right? I mean, if the FBI comes knocking, you're hard pressed not to answer.
Some of these emails which have been produced in the litigation say things like, "We're very disappointed in you, Facebook and Twitter, for not listening to our very serious concerns." So the government is careful, generally not always, but generally careful not to say, we are strong arming you right now. You better do it. They do it with a wink and a nod to make sure you get the picture that if you don't do it, there could be consequences. And Jim is being a little bit modest here because he was actually called to testify as an expert before the Arizona legislature over some of the state law equivalents. The Democratic governor of Arizona, Katie Hobbs, back when she was Secretary of State, had been interacting with social media companies in a very aggressive way. And so the legislature wanted to know Jim's opinion on the legal boundaries of where social media companies can be coerced or at least convinced to do things. And so Jim did a great job testifying as an expert.
I forgot about that. That was fun. That was fun to listen to. Okay. We don't have a whole lot of time for more questions, but I do want to give both of you the chance, your kind of last minute I don't want to say pitch. I also don't want to say soapbox. Your last chance to say your final words here for the webinar today.
Well, I'm very excited about one case we didn't talk about. It's in the First Circuit. It's called LM v. Town of Middleborough, and it involves a student who wore a T-shirt that said there are only two genders. And we filed a brief in the case in the last month or two, arguing that is a statement that you would just as much hear in your biology class or your government class when you're talking about sex discrimination. In the Supreme Court, even Ruth Bader Ginsburg had numerous opinions saying that sex is determined by biology. So I'm looking forward to seeing the outcome in favor of that. And if it doesn't end up in a good position for the student, I think that's probably going to end up at the Supreme Court.
Marvelous.
I would echo that. That's a very important case. Another case that we didn't mention kind of straddles the line again between the educational context and public employment is a case again out of Oregon and called Damiano versus Grants Pass School District, where there were a couple of Oregon educators who, in response to what they saw as an increasing trend towards gender ideology influencing their schools, made a statement. They issued like a policy proposal that was completely respectful of everybody's point of view and suggested here are some ways that we might consider handling gender distress among students that's different than the current way that things are done. People can agree or disagree about this.
They're offering a different perspective in an important public debate.
Right. But they were demoted from their jobs rather than having given respectful ear to their points of view. And they have a case that we've also weighed in on that's also very important.
That's a heckler's veto case, right? Because it was the colleagues that demanded the demotion and the school gave in to the colleagues.
I think that's right.
Terrible.
All right, so heckler's veto, school speech, public employment speech, all converging on that. That's gonna be a really interesting case to watch and important too to see how that develops. Okay, I think that covers a good amount. Like I said at the beginning, there's so much to the First Amendment and to free speech alone that we could be here for a long time. But I think we've done enough for our audience. Hopefully, you can answer your neighbor's question of what speech is protected. Now you know. I do want to thank everyone for joining us for this episode of So a Neighbor Asked. Within a week, we should have this episode fully recorded and up on our YouTube page and our website as well. In the meantime, you can be sure to keep up to date with all of these cases that we're talking about, including the Gadsden flag case, at our website, mslegal.org. You can also follow us on Twitter, now called X, at MSLF, and at Instagram at Mountain States Legal. And of course, you can find us here on Facebook. Thank you all again. Thank you, Jim. Thank you, Will, for being our most wonderful host today. We look forward to seeing you all next month for our annual year in review. So with that, thank you, everybody. Have a good day.